Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. In my youth, in roughly 1966, I spent about a year in South Dakota. It was my fifth grade year in elementary school. I went to a nice Catholic school up there, and I really liked South Dakota, although it did become bitterly cold in the winter. Today we have a case from South Dakota, and I think you may remember that South Dakota was featured prominently in the movie Dances with Wolves. And indeed, this case involves the Dances with Wolves actor, Kevin Costner, and a sculptor by the name of Peggy Detmers. And it's interesting because it talks about how contracts are interpreted, and there are some useful lessons about contract interpretation in this case. So let's take a look at that now. In the early 1990s, Kevin Costner, that Dances with Wolves guy, commissioned Peggy Detmers to create 17 large bronze sculptures of buffalo and Lakota warriors on horseback to display at the Dunbar, a luxury resort Costner planned to build on property he owned near Deadwood, South Dakota. Detmers commenced litigation against Costner in 2008 after the Dunbar had not been built. The circuit court rejected Detmers' claim and found that the parties had agreed to permanently display the sculptures at Tatanka, another project Costner developed on the same property where the Dunbar was to be built. And this court, meaning the South Dakota Supreme Court, affirmed. In 2021, Detmers brought the current action against Costner, alleging that his sale listing for Tatanka constituted an anticipatory breach of the agreement to permanently display the sculptures at Tatanka. In the alternative, Detmers sought a declaratory judgment that selling the Tatanka property and relocating the sculptures would trigger Costner's obligation to sell the sculptures under the terms of the agreement. The circuit court granted summary judgment in favor of Costner and denied Detmers' motion. We affirm in part, reverse in part, and remand. So it goes through the procedural process and where everything started. Basically, after a dispute, they entered into an agreement. And there are 3 paragraphs in the agreement that are, in effect, the sole focus of this case. Paragraph 2 says, although I will be the sole owner of the rights in the sculptures, including the copyright in the sculptures, you will always be attached through your royalty participation. And then it describes the royalty participation. Then he says, although I do not anticipate this will ever arise, if the Dunbar is not built within 10 years or the sculptures are not agreeably displayed elsewhere, I will give you 50% of the profits from the sale of 1 1/4 life-size sculptures after I have recouped all my costs, including the creation of the sculptures and any such sale. And then it talks about the sale price, and in addition, I will assign back to you the copyright of the sculptures so sold. We will locate a suitable site for displaying the sculptures if the Dunbar is not under construction within 3 years after the last sculpture has been delivered to the mold makers. In the meantime, until the sculptures are put on display, I will permit you to market and sell reproductions. So part of this had to do with her getting royalties from her creative work. So they worked on getting some alternative locations, and the project that was on the same property where the Dunbar was going to be built was known as Tatanka. And it included a visitor center and a gift shop, and that's where they decided to put the sculptures. Detmers didn't agree to that, though. She claimed she had not agreed to the permanent display of the sculptures at Tatanka in the absence of the Dunbar, and that Tatanka was not elsewhere under the terms of the agreement. In response, Costner argued he had spent millions of dollars to develop Tatanka and that he and Detmers agreed to permanently place the sculptures at Tatanka as an alternate location for the display of the sculptures under paragraph 3. The trial in Detmers 1 commenced more than 10 years after, and the court concluded that the sculptures were agreeably displayed elsewhere at Tatanka. And the Supreme Court affirmed, holding the circuit court did not err or make any clearly erroneous factual findings in determining that the sculptures are agreeably displayed elsewhere, in the absence of a guarantee from Costner that the Dunbar would be built. In the decade that follows, Detmers continued to receive royalties. Meanwhile, the construction on the Dunbar never began, and Costner sold all the properties surrounding Tatanka that had been intended for the Dunbar. In the fall of 2021, Costner listed the real estate upon which Tatanka was located for sale online. The listing expressly excluded the sculptures from the sale and indicated they will be relocated by seller. In November 2021, the Detmers brought the current action, claiming the real estate listing and statement concerning the relocation of the sculptures constituted an anticipatory breach of the agreement to display the sculptures at Tatanka, and asked for a declaratory judgment to determine her rights under the agreement. So the parties filed cross motions for summary judgment, and the circuit court granted Costner's motion based on res judicata. Remember, that means the thing has been decided, meaning the court found that in Detmers 1, the permanent display of the sculptures didn't obligate Costner to continue to display at Tatanka in perpetuity. The court also determined that agreeably displayed elsewhere language did not constitute a continuing right or obligation, and that once the parties had agreed to display the sculptures at Tatanka, Costner had fully performed his obligations. So Detmer appeals, raising three issues which we state as follows: whether the circuit court erred in concluding Detmer's claims are barred by the doctrine of res judicata, whether the circuit court erred in its interpretation of the agreement and in holding Costner was discharged from any further performance under the agreement, and whether the circuit court erred in denying Detmer's motion for summary judgment that Costner anticipatory breached the agreement to permanently display the sculptures at Tatanka as a matter of law. So the court goes through the standard of review, and basically it holds that de novo review is appropriate because they're really deciding only legal questions. And the first question is res judicata. And they say, look, res judicata involves two things. Issue preclusion refers to the effect of a judgment in foreclosing relitigation of a matter that's been already litigated and decided. Under issue preclusion, it's the particular issue or fact common to both actions that matters. Under claim preclusion, it's the cause of action itself. For an action to be barred by res judicata, four elements must be satisfied. The issue in the prior adjudication must be identical to the present issue. There must have been a final judgment on the merits in the previous case. The parties in the two actions must be the same or in privity. And there must have been a full and fair opportunity to litigate the issues in the prior adjudication. We apply these elements under both issue preclusion and claim preclusion, but as it relates to claim preclusion, our review is not restricted to whether the specific question posed by the parties in both action was the same or whether the legal question posed by the nature of the suit was the same. For purposes of claim preclusion, a cause of action is comprised of the facts which give rise to or establish the right a party seeks to enforce. Costner asserts that Detmer's current action is precluded by res judicata because Detmer seeks to relitigate the not agreeably displayed language of the agreement, and because Detmers 1 affirmed the circuit court's determination that Costner has fully performed under the terms of the agreement after the parties placed the sculptures at Tatanka. She asserts the only issue determined in Detmers was whether Detmers agreed to the placement of the sculptures at Tatanka in the absence of the resort, and 2, whether the Tatanka location constituted elsewhere under the terms of the agreement. Detmers argues the current dispute involves Costner's anticipatory breach of the agreement to permanently display the sculptures at Tatanka by stating his intention to unilaterally relocate the sculptures from Tatanka, or otherwise his intended action will trigger his obligation to sell the sculptures under the agreement. She maintains the facts and issues in this dispute were never before the court in Detmers 1. So the court says, unlike Detmers 1, the current dispute is between Detmers and Costner and centers around the parties' rights and obligations under the agreement after the parties agreed to display the sculptures at Tatanka. In Detmers 1, the sole issue at the bench trial was whether the sculptures were agreeably displayed elsewhere when they were placed at Tatanka. The court then says claim preclusion is inapplicable because there's no showing that Detmers knew or should have known that Costner would seek to relocate the sculptures from Tatanka. And that wasn't even at issue in the case. Therefore, we conclude the circuit court erred in holding that Detmer's claims are barred by the doctrine of res judicata. And then the next question is, what are the obligations under the agreement? And Detmer says that the Dunbar wasn't built within 10 years, So paragraph 3 of the agreement includes an ongoing obligation for the sculptures to be agreeably displayed elsewhere. She also claims that Costner's stated intention to sell Tatanka and relocate the sculptures is an anticipatory repudiation of the agreement of Detmers 1 to permanently display the sculptures there. The Circuit Court adopted Costner's assertion that his obligations under paragraph 3 of the agreement could be satisfied in one of two ways. The Dunbar is built within 10 years, or the sculptures are agreeably displayed elsewhere within that time frame. Under this reading, Costner argues the Circuit Court correctly reasoned that he'd satisfied all of his duties. Costner claims the construction of the agreement is consistent with Circuit Court's determination in Detmers 1 that Costner has fully performed under the agreement. However, the current dispute is controlled by the express terms of paragraph 3 of the agreement and whether Costner can relocate the sculptures from Tatanka without triggering the sale of the agreement, not by any implied agreement found by the court in Detmers 1. So, contract interpretation is a question of law. It's reviewed de novo, and they state the principles, and then they say, consistent with Detmers 1, we determined the controlling language is unambiguous. So they agree it's unambiguous. Under the plain language of the agreement, the Circuit Court erroneously read not agreeably displayed elsewhere to expire after 10 years. This reading of the language in paragraph 3 and the conclusion that he'd fully satisfied his obligations conflict with the rules of grammar in extending the 10-year time period for building the Dunbar to not agreeably displayed elsewhere. In the first sentence of paragraph 3, the phrase within 10 years immediately follows the word built and is separated from the word displayed by the conjunction or. As a result, within 10 years modifies only built. Conversely, displayed is not affected by within 10 years. Thus, the plain language of the paragraph 3 establishes that not agreeably displayed elsewhere is not limited by time or duration. And what that means is that essentially Costner loses again. A condition precedent is a contract term distinguishable from a normal contractual promise in that it does not create a right or duty, but instead is a limitation on the contractual obligations of the parties. A condition precedent is a fact or event which the parties intend must exist or take place before there is a right to performance. Paragraph 3 imposes a contingent obligation upon Costner to sell the sculptures, divide the profits with Detmers, and return the copyright to Detmers upon the occurrence of two conditions precedent. Although I do not anticipate this will ever arrive, if these conditions occur, I will give you emphasis at emphasis at it. The Dunbar was not built within 10 years, meeting the first of the two conditions necessary to trigger the sale clause. The second condition is that the sculptures are not agreeably displayed elsewhere. As discussed above, the agreement places no time limit on when that second condition may be satisfied or the obligation triggered thereby. It's the fundamental rule of contract interpretation that the entire contract and all of its provisions must be given meaning if that can be accomplished consistently and reasonably. It's important the court found that he included the 20% gross retail royalty. He says these terms provide Detmers with a continuing interest in the location and display of the sculptures because the value of the royalty payments is integrally related to whether the sculptures are displayed at a location likely to attract visitors and result in more sales of reproductions. If the sculptures are not agreeably displayed elsewhere, the contingency provision for the sale of the sculptures ensures that Costner recovers the costs that he incurred and the sculpture's creation, and that both parties share any profits from the sale of the sculptures, and that Detmer retains the copyright for the statues. So, thereafter, paragraph 3 has applied since 10 years passed without the Dunbar being built and requires the sale of the sculptures unless the parties are in agreement about the display location. Contrary to the Circuit Court's reasoning in this action, the Circuit Court's conclusion that Costner had fully performed was not a judicial determination that Costner had no further obligation under the agreement. Instead, it was the determination that Costner was not obligated to sell the sculptures because the sculptures' placement at Tatanka was elsewhere and they were agreeably displayed elsewhere. Costner's decision to unilaterally sell Tatanka and relocate the sculptures would trigger the clause in paragraph 3 unless the parties agree to another display location. So then she brought this action for anticipatory breach, and basically what the court says is this isn't an anticipatory breach because it's not certain to occur. It basically says a breach of contract caused by a party's anticipatory repudiation, unequivocally indicating the party will not perform when performance is due. And that's not what the situation is. He hasn't made any determination that he won't perform. Instead, what he has said is he has a different view of the contract. And as a result, they do not give her the declaratory judgment that he's obligated to sell the statues. Rather, what it says is if he doesn't sell the property, the sculptures have to be sold unless they can be agreeably displayed elsewhere. So that's how the case wound up. There is always a problem when you draft an agreement yourself, because you read, when you proofread it, what you think you wrote. You don't read it with the critical eye of a lawyer who looks for alternative possible futures. One of the things that lawyers are good at is looking at ways that agreements can fail. In other words, if you enter into an agreement with somebody and you're going to write a contract and you tell them that you're going to do several things, what happens if only one of those things doesn't get done? What happens if they all don't get done? You have to prescribe remedies for every situation. Basically, you have to be a good science fiction writer and imagine alternative possible futures. What if your partner develops cancer? What if he has to sell his assets in order to fund his cancer treatment? There are hundreds of different things that can happen in the context of an agreement that make it difficult to predict exactly how an agreement may fail. Plain language contract writing helps, but even plain language contract writing, and I think that's what they attempted to do in this case, can still fail. And Costner obviously thought that after 10 years he would be able to do whatever he wanted to with those statues. Unfortunately, that's not how it works, and the court accurately did the grammatical analysis, and the grammatical analysis here essentially locks this down. If you have a conjunction in between, or in this case a disjunctive, if you have the disjunctive in there that says or, then clearly you have two sets or two phrases, and the words in one phrase almost never modify the words in another phrase unless that word is repeated. And so the court got this one absolutely right. It's good to see that. That's the moral of the story in this case. That's the takeaway. Get a lawyer to look at a contract before you sign it. If you don't sign it until you get somebody to look at it, you're not going to be surprised by the terms that are in it. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know all the things we ask you to do. And the one thing I always ask people to do is to try and do something nice for somebody today. You know, sometimes it can be a pretty ugly world out there with people saying things that are snippy and cutting people off in traffic. The next time somebody cuts you off in traffic, smile and wave. Because you know what? At the end of the day, 20 years from now, you're not going to remember that. They're not going to remember that. Unless, of course, you know, a road rage incident occurs, and then you might be remembering it in the hospital. So, again, try to do something nice. Try to be kind to people, even when they're unkind to you. It'll make them feel bad. Thanks for watching. Have a great day. Catch me down here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.